So this was what your exercise was on drafting confidentiality, non-compete and non-solicit clauses. And there's an Indian pharmaceutical company which is in the business of manufacturing multivitamin tablets. And it's developed a formula for athletes, which they are branding as Rejuven Plus. And these tablets will help athletes to overcome body fatigue and rejuvenate faster. Okay. And they are looking to associate with a Japan-based pharma company, Emiko Pharma, to manufacture and distribute Rejuven Plus in Japan, because it's believed that the shelf life of the tablets is quite low, and manufacturing in India and transporting it to Japan will not work. So now LP is planning to launch the medicine before the Tokyo Olympics, and it will license the patent for Rejuven Plus. There's an extra A in there, to EP, the Japanese company. And the Japanese company will manufacture and market that product in Japan. And the Japanese company will pay royalty and technical fees to the Indian company for manufacture of that medicine. Okay. And now we are going to have to draft here a confidentiality clause and a non-compete clause in the licensing agreement. Does everybody understand the transaction here? Does everyone get the transaction that is happening?
It's a license agreement.
Sorry, I can't hear you.
It's a license agreement?
It's a licensing agreement, correct. So the Indian company is giving the intellectual property for use to the Japanese company, and they are expected to manufacture the product with the use of that IP. Okay. So given that it's a drug, obviously there is a formula for making that drug, which is going to be transferred from the licensed, rather not transferred, from the Indian company to the Japanese company. So that is what is happening here. Now, from the point of view of confidentiality, okay, the concerns of the Indian company will be that the Japanese company can leak this formula, right? So that product, the formula for that product will be out in the open, or they can use it by themselves and create a competing entity, okay, of the Indian company. So that's why what they are doing is that you're going to use this technology, you're allowed to use it, but you are not allowed to disclose it to the outside people, and you are not allowed to use it yourself to create a competing entity, a competing business for the Indian company. Okay, that's what is the restriction that is being placed. So let's look at now the submission. I've opened up Vandana's submission here. And I can say that she's tried to draft the clauses from the scratch. Okay, she's not taken things out from the template. She's tried to draft it from the scratch, which is really good. Okay, so the confidentiality clause first. So the way it is being put is that by default, all information shared by LP in relation to intellectual property being licensed is confidential, including but not restricted to the formula, trade secrets, sources of material used, proportion of each ingredient. Dosage will be when it is administered to a person. Okay, so dosage is not going to be confidential in any event. When you put it on the wrapper of that medicine or whatever which you're doing, it's not going to be confidential. But the proportion of the chemicals or the formulations used in making that medicine, definitely that is confidential. So this can be okay. However, it might be a better idea to define, okay, and say, so depending on whose side you are acting on, have we stated that? So you are from the side of LP, from the manufacturer's side. So it makes sense to classify everything and keep a broad definition of what is confidential information. Okay, and since this is a licensing agreement, it is more related to intellectual property which is being licensed. So definitely this makes sense. Okay, so confidential information is, and you can even include in this, so you can define if you want to, you will say that confidential information is all of that, the formula for the creation of the drug which winner plus, and all the information required in order for the manufacture of the drug as indicated in annexure A. And in that you can write the entire details, all ingredients, everything you can write for that drug, right?
Komal ma'am, can we write confidential information shall include the formula?
No, it's not. You. In fact, instead of is, you write means. Okay, means the formula and all the information that's connected with it. That's what you will write. Why do you want to keep an unnecessarily broad? Anyway, here you are restricting that. So you are saying that this is a good way to put that by default, all information shared by LP in relation to the intellectual property being licensed is confidential. And understand that this is a licensing contract. In this, the company is not going to give information of its customers or business model or anything like that. Okay, the only thing that will be shared with the Japanese entity is the IP for the drug. That's it. No other business related information is going to be shared in this agreement because it's restricted. It's a licensing agreement and that's it. Okay? If it were, let's say, a technology transfer agreement where a lot of things in detail are being transferred, okay, then you would put all of those clauses and then you can make an inclusive definition. But here the transaction is very restricted. They are licensed to use, or they have license to use that formula or that patent for the drug. Okay, so means the patent. So you should actually the patent, the formula for the creation of the drug and all information required in order for the manufacture of the drug as indicated in the annexure. And then you say that by default, all information shared by LP in relation to the intellectual property being licensed is confidential. Okay. Here also you can define intellectual property, and you can define it as the patents number so and so, granted on so and so. All of those details you can put. Okay. Or here, rather, in fact, confidential information, you might actually define intellectual property because it's a licensing agreement. Okay. And by default, all information that's shared in relation to intellectual property is confidential, including but not restricted to the formula, trade secrets, sources of materials used, proportion of future value, etc. The receiving party agrees that all confidential information shall be treated as, so here let's put it in so that you what is confidential information? That's what you're defining. Okay. shall be treated as absolute secret, as an absolute secret, and the receiving party shall not disclose to any person such information otherwise than in terms of this agreement. They will just not disclose it. Okay, and even if you want to allow them for the use, you will just say except with the consent of LP. Okay, and LP may be defined in the agreement as licensor. Okay, because that's what they are. Receiving party will impose a similar, and instead of receiving party here, usually see if you are putting LP as the short form for one of the parties, so this is not a two-sided agreement. Okay, this is not two-sided confidential agreement. Confidential agreement is not flowing from the Japanese company to Indian company. It's only a one-way flow from the Indian company to Japanese company. So that is why you don't need to define it as receiving party or something. This is a licensing agreement. You can simply say licensor and licensee. Okay, so instead of LP here, you can say licensor. Okay, and instead of the receiving party, you can say the licensee. And the licensee shall not disclose to any person such information except with the consent of the licensor. Okay. The receiving party, the licensee, will impose a similar duty of confidentiality on the person to whom the receiving party, the licensor, is permitted to transfer such information in accordance with the terms of this agreement. Okay. So, Vandana, are you seeing here? Is Vandana here?
Yes, ma'am.
So, Vandana, see, you have used alternate and you have used different terms for the same party in drafting the clause. Okay. Here you have written receiving party. Here you have written EP, then in bracket receiving party. So it's better to I like when you define the parties clause. Okay, at that point itself, you will put the name of or the definition of the party or the short form you're going to use for the party, and then continue with that throughout the agreement so that there is no confusion as to who is who. Okay, so here again we will say that notwithstanding anything contained herein, the obligations of the licensee to retain secrecy of, not retain, maintain the secrecy of confidential information shall survive and be continuing until the confidential, not however, it's not required. Until the confidential information is no longer confidential and is in the public domain without any breach of the terms and conditions hereof. Do you understand this clause, Vandana, or you have taken it?
No, ma'am, I've drafted it.
Yeah, but you understand what this is for, right?
Yes.
Okay. So you were just saying that requirement will continue until the information is no longer confidential and it comes into the public domain. So it should be by the licensee here. My bad. Okay, the licensor will retain all rights, title, and interests to its confidential information. Actually, it will be intellectual property. except except for the license granted to the licensee in terms of this agreement. Okay. This agreement does not grant use of any other intellectual property that the licensor owns or may own. Based on its confidential information except for that granted by, and then agreement you will put in capital because that also will be defined. So you will not write licensing the, because you will define that agreement is this licensing agreement. Okay. Remedy for any breach. So you will not say breach, but any leak of confidential information shall provide the party at loss the right to injunction and indemnification without liquidated damages, and these rights shall be available simultaneously. Okay, this is a very confusing clause. Confidentiality clause shall be excluded from any limitation of liability. This sentence is correct, but the one in the beginning, what is it that you want to do here, Vandana? What is the effect you want to achieve here? The effect is that the person shall claim damages, right? For whatever is the
Claim that injunction and damages, unliquidated damages. So
yeah,
both can be attained together, not like one after the other.
yeah. But the drafting does not make that very clearly. Okay, very clear. Okay. So the better way can be that in the event of breach of confidentiality as indicated at clause number X, whatever, the licensor shall be entitled to seek remedy in terms of injunctive relief as well as damages. Okay. As well as damages. For the loss caused on account of such breach of confidentiality. Okay. And then in this clause, so this will be in indemnification. This will be a different clause and it will be in under the heading of indemnification. Okay. And then this, you can either put in indemnification or you can put in under the confidential information clause. Okay. So confidentiality clause. So the requirement to maintain. So rather confidentiality clause number. Actually, it will not, it's not a clause, okay? But it's rather the requirement to maintain the confidentiality. So even this can be drafted a little bit better. Clause at number. The requirement to maintain confidentiality as stated in clause number so and so shall, or rather, what's the better way to draft it? The licensee, in the event of a breach of confidentiality, as indicated at clause number dash, the licensee shall not be able to claim any limitation. Okay, that's, I think, a good amount of clarity. Okay, non-compete. After termination or expiry of this licensing agreement, Amico Pharma shall not manufacture products which are identical or similar to the formula of the tablets of Landmark Pharma Limited. You have to restrict during the agreement also now. Otherwise, they will say that it's not expired. we can do this. Okay? So during the tenure of this agreement and for 2 years after the termination or expiry of this agreement, okay, the licensee shall not manufacture products which are identical or similar to the formula of the. Actually, they can't. Anyway, they won't be able to, because if they do that, then it will become a infringement, because this is very limited. The license is very limited in duration. Okay, license are not, it can be perpetual, but here we are not saying that it is perpetual, so it will be limited. So if it's the tenure of the agreement and 2 years thereafter, then after that, if the Japanese company uses it, it will actually become infringement of intellectual property. So they're not going to do that at any point of time afterwards anyway. Okay. But similar to the formula, you should not do even similar, identical or similar. So it's not only exact, but you should do even identical or similar to the formula of intellectual property being licensed through this agreement. Okay. The licensee agrees that it shall not share, sell, or in any way make available the formula to any of its, not its competitors, competitors of the manufacturer. Okay. It is dangerous for them to make it available to their own competitors anyway. Okay. But what will it do? It will make by itself, and after it has made some decent profit, it can just go to another manufacturer and it can sell or inform that formula to another manufacturer for money. Okay. So the manufacturer doesn't want that. Licensee agrees that it shall not share, sell, or in any way make available the intellectual property being licensed to any of the competitors or competing entities, businesses, business organizations, or any other persons, including natural persons, legal or natural persons. Any competitors of the licensor or any competing entities, business organizations, or whom. Okay, let's move to the other situation now. Okay, Supertech Gaming has just entered into a services agreement with Solus Tech developers, whereby the developers will develop customized software which helps them to maintain a leaderboard for games. For this purpose, they will be arranging for secondment of employees to this client for 3 months to develop, and the developer is now concerned that the client is going to take away their employees. So for that, they want a non-solicit clause to be included in the services agreement. What is the transaction here? The transaction is a services agreement, and the developer is concerned that the client can take away their employees. Okay, it's not the opposite. Okay, so the secondment company shall not solicit, encourage, induce, or attempt to solicit the employee for employment during the term of employee's secondment and even after the secondment period. Good attempt, but there has to be better drafting, little bit better drafting. But good attempt as in you are trying to draft it entirely from scratch on your own. Okay. So here your clause will be that, see, what will be a definition in a service agreement? One of them is a service provider and the other one is, if one is a service provider, what is the other one? What is the other party called?
Recipient.
Either recipient of services or client or simply company. That's how it will be defined in the agreement, isn't it? When you look at the parties, okay, so let's say XYZ developer, whatever, who are the service provider, hereinafter called the service provider, and then XYZ, hereinafter called either the client or the company or the recipient, whatever. You can define it as recipient also. Recipient is a little bit not matching, because in that you are simply saying someone who receives it. Okay, in here you are saying that they're availing the services, so you might want to define it as client or even simply as company. Okay, client can be a better word, so you will say that the client, okay, shall not. So again, like it is during the term of this agreement and for 6 months. In this case, putting 2-year restriction doesn't make sense, because like there can be very rapid job changes. There can be like people not remaining there anymore. There can be lots of different things like that. 6 months is a good enough period, because after secondment, it's a long enough period. In fact, you might even want to say 3 months after that. Okay, so during the term of this agreement and for 6 months thereafter, the client agrees that it shall not solicit any of the employees of the service provider and cause them so as to cause them to cease their employment with the service provider. Okay. Does this make sense? Okay. So it will not cause them to leave their employment with the service provider. Okay. And it's not a concern that they may be working 2 times, because usually the employment agreements of these guys will have provisions that you can't continue in 2 employments at one time. Most employment agreements have these employment agreements, most of them, unless it is specifically for part-time, have this clause that simultaneously with this employment, you cannot take any other employment or jobs. Most of them have this clause. Okay. So the point is that like you can't like cause them to cease their employment, and you can't make them double work also, because the employment agreement will anyway have this clause that you can't do anything else together with that, right? So that's how it will be restricted. Anything else you think should be added to this clause? 6 months is a very wide period. In fact, it can be lesser than them. There is just a software development that is happening, like, you know, how long it is going to take for a developer to do that, and the employees are going to be there on secondment. So in that duration, and the term of the agreement will barely be 3 to 5 months, because that can be like, you know, a typical period required to develop proper software. 5 months, like, you know, maximum, whatever. So not to restrict employees if there is employment offer in general. Yeah, but the client will not cause the employees to leave that. 1 or 2 years is too long in this case, because they are there only for 3 months duration and you are not doing anything for 6 months. How long can you, like, you know, keep someone in? Okay. And in the IT industry, highly unlikely. And people actually do this. Okay, like I've definitely seen auditors, employees being taken away by the client and they don't do anything about it. Like, you know, they come to audit on the clients at the client's place, and the client hires them afterwards. Okay. To draft a non-disclosure agreement. Let's see what this one was for. Okay, here this is a very valid concern. This is an investee company and an investor, and the investor has stake in competing entities. Okay, so definitely they are interested that, you know, until everything goes through, like, you know, there is, even at the time of due diligence and everything, they don't want that the investor should share or use that information in any manner. So definitely there has to be a non-disclosure here. Okay. So you have to draft a non-disclosure agreement. This agreement is made on this 15th day of March 2021 by and between Good Basket Private Limited, established under the laws of India. There are no laws of Mumbai. Under the laws of India, and having, you can always put this as company registered under the Companies Act, or you can say company as per. That's a better way to put it instead of registered under, because people people face issues that I was incorporated way before the 2013 Act. So then, like, I am registered under 56 Act and 56 is not there in place anymore. So the better way to put is that a company within the meaning of the Companies Act 2013. So even if you were registered in 56, you can still say that you are a company within the meaning of the Companies Act 2013. Okay. Established under the laws of India and having its principal place of business at Mumbai, hereinafter referred to as disclosing party, which expression shall. So good, you were to understand that where is the information flowing in an NDA. That's the thing that you have to understand. And here the information is flowing only one-sided from the investee entity to the investor entity, right? As the disclosing party, which shall, unless repugnant to the context or meaning thereof, be deemed to mean and include its successors and permitted assigns of the first part, and Lucifer Capital LLC, a company incorporated under the laws of United States. This is now interesting. See, in India, there are central acts for creating companies, while in US, the incorporations are state-based. So you will always say incorporated under the laws of and having its principal place of business at Delaware, because there is no uniform one law for incorporation of companies. They have something that's called a uniform commercial code, but the adoption of that is up to the states. Okay, and the states have their own corporations code. Okay. So you're going to see this as we progress to the companies part, that how the country laws impact. Okay. So Lucifer Capital LLC, company incorporated and the laws of and having its principal place of business at under the laws, let's put it, okay, the state of and having its principal place of business at. So we can put the address here. Okay. Receiving party, which expression shall be deemed to mean and include its successors permitted assigns. Disclosing party is engaged in the business of providing community building foods. Disclosing party and receiving party are interested in discussing the possible investment agreement. Rather, you would say investment transaction. The parties acknowledge that during the course of discussions between them, the receiving party shall become privy to certain confidential information relating to disclosing party, and the receiving party has agreed to be bound by non-disclosure provisions of this agreement to govern the use and disclosure of confidential information. Okay, in consideration of the mutual promises and agreements between the parties entered into this agreement. So for the purposes, confidential information shall be such information relating to disclosing party as disclosing party may from time to time provide to the receiving party under or relating to this agreement. Okay, this is fine. Not limited to ideas, formats, formulas, improvements, product plans, non-public market information. Product plans is already covered. So again, we want to cover it. Vandana is facing network issues. Can everyone else hear clearly? Am I audible clearly to the rest of the people? Okay. Vandana, you can then check, either you can work on your audio settings now, or you can check the recorded session. But be here, you might be able to, even if you can't hear, you can see the screen. Okay, you can see the changes I'm making in the drafting. Okay. Here, just understand, this is a due diligence exercise. When it's a due diligence exercise for an investment transaction, more or less everything will be disclosed to the investor. Okay, in a due diligence exercise, depending upon the depth, a lot of information. It's not going to be restricted like our licensing agreement as we saw. There was only specific type of intellectual property which was being disclosed by the licensor to the licensee, not its business models, not its customer lists, all of those things. But in a due diligence, everything becomes made available to the investor. So in this case, it makes sense to keep this as broad as possible. And in this sense, in this case, it's actually a valid case where you are going to bring the generalistic clause that anything that is disclosed by the disclosing party in the course of due diligence being conducted by the receiving party is considered to be confidential. Okay, because lots of things will be transferred. Okay, it makes sense to bring the overlapping clause here, stating that anything that is disclosed to the receiving party in the course of the due diligence being held by the receiving party shall be deemed to be confidential. Okay. The receiving party recognizes that it will be private or confidential information. Everything in this agreement will hinge upon how the confidential information is defined. Okay. The remaining things are just like cursory how it works or how many exceptions you put to it. All of those things are just like, it's more boilerplate kind of. But a lot of things will depend upon how you define the confidential information. Okay. So it will not, without the prior permission, directly or indirectly disclose or cause to be disclosed the confidential information. It will take all steps to protect integrity. It will promptly inform disclosing party of any incidental disclosure. Receiving party shall use it only for the purpose for which it was provided, not profit from the same in any unauthorized manner. This is very important, because just understand this, the investor gets all of this information. Now, even if this transaction does not go through, they can use that information to benefit the other company in which they have put the money, so that the price of the other company will increase. So this is very crucial that you have this clause. They will not profit from it in any unauthorized manner. Okay. They will restrict and adhere to the provisions mentioned above, except to the extent that such confidential information is already in public domain, other than by breach of this agreement, to the extent that such confidential information is required to be disclosed by applicable law or applicable regulatory requirements, or by any regulatory body to whose jurisdiction the receiving party is subject, or with whose instructions it's customary to comply under notice to disclosing party. Okay. Insofar as it's disclosed to employees, directors, partners, financials, or professional advisors of the receiving party, provided that receiving party will procure that such persons treats the confidential information as confidential. Okay. to the extent that any of such confidential information was previously known or already in the lawful possession of the receiving party prior to disclosure by the disclosing party. Okay. Will not accept and to the extent required make any copies or reproduce the confidential information. Copies or reproductions will be subject to terms and conditions of the agreement. Okay, and they will take all steps as necessary to restrict access. Parties acknowledge that due to the extent of the disclosure of confidential information, the receiving party, I just told you what the unauthorized manner is, right, Pankaj? That they will use that information to benefit the other competing company in which they have stake. Okay, so they should not do that. Okay, we have concerns here that the investor has stake in the competitor. Now, if this transaction goes through, if this investment transaction goes through, definitely then the investor will not disclose it to the competitor because they have put money in this company also. Why will they want the business and everything of this company to be like leaked? Because they have stake in it, their money is in it. But until the money is in this company, they will not want it to be used by another competitor company, right? They have put money in another company. So like in a due diligence exercise, they come to know a lot of things of this company and then they make that information available to the competing company in which they have stake so that it can increase its sales and the prices go up and they benefit from the investment. That's something that they can't do. Okay? Especially since the investee knows here that they have stake in a competing company.
In the event, like if they do not invest in this company and subsequently they utilize this information in an unauthorized manner, so is there any remedy?
That is what we are looking at.
Okay.
This is injunctive relief, right? They acknowledge that due to the extent the receiving party understands that disclosing party will suffer irreparable damage if they breach their obligations. Okay, and monetary damages will be inadequate to compensate. They acknowledge that in addition to other remedies of rights, the disclosing party will have the right to obtain injunctive relief to enforce the terms. That means stop giving any of the information to anybody else. Number one. And then two, the damage that you have caused by leaking this information, whatever you've done until now to the other person, you are liable for that damages. Okay. So, to enforce the terms of this agreement, dispute resolution and governing law. Place of arbitration will be Mumbai. You should put, there is no term of this agreement, okay? There's no term or there's no duration of the agreement. So it's kind of forever. Okay. Or you can put that the term will be until it becomes public. As we did in the first case. So you can say that the obligations in this clause (2.1) shall continue until the confidential information becomes public in any manner other than by the breach of this agreement. We are not putting a term on non-disclosure because there is too much information that gets provided in a due diligence. Will these damages be of all kind or any specific kind, like all claims can be taken, or it depends on discretion of court for disclosing confidential information? Yeah, well, you will not, the thing is you will not put a limit on it, or you will not put a number on it at this point of time, because in a due diligence, the information is like comprehensive. If that is leaked, like kind of everything about the business will be leaked. Okay.
Hello, I'm Lakshya this side. This is specific to the due diligence part, or like any of the agreement, like if we enter into the master agreement or any other NDA, which is very transaction specific. So this the like limiting of the clause is unlimiting the clause is applicable to all of the agreement, or it is a client specific one.
You will prefer not to limit it. You will prefer not to limit it because you don't know, like it may be only single information, like the licensing agreement that we saw before. But if
Yes.
that formula is leaked, then the whole business around it can crumble, right? It's the business on which, it's the information on which everything hinges.
For example, if we are at the receiving party, then how can we negotiate on that?
If you are the receiving part on the damages aspect,
No, if we are like the two parties are in the NDA, so one is the disclosing party and another is
yeah,
the receiving party. So if we are in at the receiving party and we have to limit our liabilities to the agreement, how can we like negotiate on the clause? Like the disclosing party will be keeping it very broad one, and we want to like narrow it down that on or only the information which is disclosed in this, not any of the affiliates the any of the other entity information if it get leaks, or though they are party to this one, but any of the information which get leaks or the receiving party is not hampered or not held liable for that. Is there any borderline where we can
I did not
negotiate on that?
understand what is the saving grace that you want. It's a business transaction that is happening. There is some confidential that is information that is being transferred. Why are you in this zone that you want protection? So you are saying in the case of accidental leaks. Okay.
Yeah.
So
Yeah, for example, like
accidental-
if there is a server failure, or like if any of the uh, there are like various security measures which the company has to take care when they are when they are receiving any of the confidential information from the disclosing party. For example, like any of the SOC requirement which we are not complying with, or any of the ISO requirement which we are not complying with during receiving of this information, but after during the transaction we happen to enter into all this certifications and all, but uh, during while the time of entering of the NDA we were not complying all these things, and accidentally during the course of the business any of the information get leaked. So I am on the receiving party who is negotiating for the NDA of the receiving party. So any of the borderline which or the any of the formulas by which
the
we can
logic
negotiate.
is, the simple logic is that anyone who gets access to this information must be bound by similar requirement of confidentiality. If you have an auditor or if you have someone who is looking at your systems, you can have people who are looking at your systems or processes or all of that. The only thing is when you uh, agree with them for conducting that assignment or the project at that point of time, you enter into an NDA with them also, and it has to have the similar impact as this NDA. It cannot have lesser relevance than this. Okay, so if this is saying that if the spread is this, is the confidential information, then that's the confidential information for whoever is looking at your business also. If they have come across all of this in the process of audit or inspection or examination or whatever it is. Okay, so you're going to put similar confidentiality requirements on them, and that's the requirement that we have put here. Other than that, if there is a situation or there's a concern that you have in terms of accidental leaks, and accidental leaks where you do not have control and it gets leaked for whatever reasons, like, you know, it gets leaked because of for nothing, none of your fault. If it gets leaked by hacking, okay, or things like that, then it is very clear that, you know, your systems were not appropriate enough. So you did not take care enough for things not to get leaked. But if it get leaked by whatever other reasons, like let's say that there is some natural calamity or something and your things gets damaged,
That will be covered in the force majeure, I think so.
then you put it in the force majeure clause.
Any of the like disclaimer clauses can be added in this one.
There is
For
no
which we
disclaimer clause. There will be a force majeure clause that if due to the act of God or circumstances totally beyond the control of the receiving party, things get leaked and come out, then the receiving party will not be responsible. But in most cases like this, okay, the requirement is there on the receiving party to ensure that it does not get leaked. They have to have systems strong enough. They have to ensure that whoever gets access to the information has similar confidentiality restrictions. Okay.
Okay.
So that it doesn't cause damage to the person who is entering into a business transaction with you. Why would you want to do that? You also don't want it to be, right? So accidentally, if it happens, like a force majeure, okay, then it's a different thing altogether. But otherwise, things are very much in your control, not to let it go, right?
Okay.
Any questions on this? I mean, think from your, if you were giving your information to someone, would you accept that as an excuse that, you know, there are very smart hackers and they hacked my system and they took away? Would you accept that as an excuse? You will say that it's your job to keep your systems safe and secure, right? So it becomes very difficult, and for the receiving party, you can't claim it or you can't make a claim like that. There are certain things that you can claim, okay, that despite us doing all protections and everything, this has happened. So damages can be reduced in that situations, but you can't escape by it. You can argue before the court that, look, we did everything that was possible. But the person who has lost that information will definitely act on it.
Actually, the thing is like in the today's scenario where the work from home culture is there, so the people are working directly on the servers of the company. So like though like if there is a financial transaction going on, we make sure that that the people who are working on the financial projects come in the company and work in that premises only.
Yeah.
But like due to government officials and the requirements of like if the lockdown is imposed, then we have to allow them to work from home only. So like there are few of the projects of ours which are highly financial one. So and the it's a BPO transaction going on there. So like in the US, in India we have the what do you call it, OTP system in the credit card, but in the US we don't have. And if any of the person who knows the credit card number and want to like knows the credit card number and the expiry date of that credit card also, so he can go and do the transaction on that.
Yes.
So I was concerned on that part only. Like, is there any of the disclaimer we can add to any of the agreement?
That is too wide or too vast a concern to be addressed by a confidentiality agreement.
Yeah.
Okay.
Yes.
So where companies are in this zone, and I'd suggest we are having a data protection and privacy boot camp on the 20th.
Yeah, I'm attending that.
Attend that.
Yeah, I'm attending.
Here, that's where this thing goes, okay? Because you have to have your systems, you have to have your network, you have to have your things, you know.
Like we comply to the SOC requirements, we comply to the ISO requirements also.
Yeah.
Various certifications we have, and for the data processor also we comply with GDPR. CCPA also we comply to. The
So
thing
for
is
the
like if
employees, you have to have that kind of code. Okay, remote working code you have to have. You can have monitoring systems on the code. You can find out, like, you know, you can, like I'm sitting here right now. If you see on my screen, there is a small thing here which says working, right?
Yeah.
So there can be monitoring systems like this, which take screenshots of where you are or how you are. Okay, is there anybody behind? You will be able to see it.
okay, that so we are having, but the thing is like if the person doesn't log into that, like if, 5-day week it is there. So on the Saturday Sunday, if the person memorizes it, or if that person note it down in somewhere and get the access of some other system and then try to hack it. So that all requirements like
This doesn't go into the realm of confidentiality. This goes into the realm of your data protection systems, and it also goes into the realm of your employee codes or manuals which you impose on them. Okay, that they can't give their any access or anything to anybody else. If they are doing certain things, they must be alone. All of those things you have to impose as a company on the employees.
that NDA, everything is there on the place. The thing is like there is a chance. There is a chance like
There is a chance. But that cannot be sorted by an NDA. That has to be sorted by your own data protection and privacy systems and your own employee codes and manuals. Too broad a thing to be addressed by an NDA.
we can't disclaim any of the things with our client, like by adding an addendum to the NDA
So you are saying that you want to do away with that requirement in order to, so if something happens because of that, but even then, I don't think this argument falls into place, Lakshay, because it is your job again to keep your systems and your employees in check, okay, and to ensure that the things don't get leaked. As far as the opposite party is concerned, they are going to come and catch your throat. They will not say that just because you're working from home, it's okay that their information gets leaked. No one will accept that argument. Would you accept that argument?
No, being at the disclosing party, I won't be accepting it.
Then,
but at the receiving party, like I have to save myself.
So what you can, even then, the disclosing party will go to court. Then when you reach the court, there you can argue that, look, I did everything that was possible. Okay, I created logs, I created codes, I imposed things on the employees. I did everything here. Okay, and yet it has happened. This has happened. So it's not like I wanted it to happen. I took all due protections and took all due efforts. Now in that situation, the court will see, and they will like, you know, determine accordingly. They will see that like everything that was done was by the receiving party to ensure. Still, this has happened. Sometimes you can't control things, so the damages will be decided accordingly. If there are lapses from the receiving party, and they are casual about doing all these things, then the damages will be higher.
Okay.
Right?
Yeah.
So in the first instance, it will go to the arbitrator. And because one of the parties is Indian here, and in its information is being disclosed, it's very logical that you choose that as governing law. Okay, and it will be governed in accordance with laws of India. This is fine. Okay. No forbearance, indulgence, relaxation, or inaction by disclosing party will affect, diminish, or prejudice its right to require performance of the provision at a later point. If any provision is held to be invalid or unenforceable, reminder will not be impacted. Okay. This is all fine. Indemnification. Receiving party hereby provides complete indemnity to the disclosing party for any loss or damage caused to the disclosing party or any of its affiliates and assignees due to breach of obligations of the receiving party under this agreement. Okay. Here if you are on the receiving party's side, you can have force majeure brought in. Okay. And lockdown is not force majeure. Okay. And you can word it that's where you will say that in my control, I did everything in my control to restrict the thing, and yet this has happened. Okay. So you may want that as protection. Okay. And if you are a lawyer to the receiving party, you may have a force majeure here, and you may define it as any event beyond the control of the receiving party.
Ma'am?
Yeah.
Ma'am, in this for this agreement, like for NDA, the force majeure for like lockdown as a situation, force majeure will not be applicable. But what if in different agreements, like if there are different contracts or agreements, force majeure lockdown will be a reason? Will
It
that be a
depends
reason?
on how it is defined in the agreement, actually.
Okay. Okay.
Okay. Okay. Any other questions? Any other
Excuse me,
questions
ma'am.
on this?
I have a doubt.
Yeah.
Ma'am, in the force measure clause, as you have said earlier, like we have to define, we have to mention each and every events, or is it not vague to write it like in this way, how you have written?
Any event beyond the control. That's what
Yeah.
I'm saying. As a lawyer for the receiving party, you may try to put this. If it goes through, then it's okay. Then you are survived. Otherwise, the opposite party will say that I don't accept this. This is crap. Please limit it and make it specific. Okay. Because Lakshay was specifically asking, if I'm a lawyer for receiving party, what should I do? That's why I'm saying.
Okay. Thank you, ma'am.
Okay. Any questions? No? Okay. Great. Thank you so much, guys.
No, ma'am.
15 people came in.
Thank you, ma'am.
Thanks. Bye.
Hello, ma'am. Lakshya this side.
Yeah, Lakshay.
Thank you, ma'am.
Okay, so I want to know about the non-solicitation one. So I didn't attend that class actually.
Non-solicit. Okay.
Yeah, the thing is like I had a very practical example of that in this work from home one. So like from 2020 till now we are on work from home. So one of the engineer joined us, and he was working with us. We are having the NDA with him, and we were having the employment terms with him also. So as per that, he was not allowed to take any of the part-time or the full-time employment with any of the competitor of the company who are in the same line of business. But though he was employed with us, and he took the employment with some other organization also. And during the audit of the PF, we got to know that he was getting the PF from another organization. So we went to the civil one. But is there any of the criminal liability which we can impose on him?
In an employment agreement, what else can you impose? It's a civil agreement.
Yeah, it's a civil one, but like I went through all of the section of the IPC. I went
I
through the
don't know.
employee.
Do you want to? Is it you want to take it under criminal breach of trust. I don't know how.
But criminal breach of trust, like the police officials doesn't recognize it. They say
Absolutely, no, it
they
is
say
very, it's not going to, it is a civil contract. Okay, so that's what you
they
would be
say
doing.
like it's a highly civil.
And the big problem here is that if you haven't even locked his salary for some period of time, even if you've locked, like, that is the best you can get in this. Otherwise, the damage that you can do is to go to other people and tell them that this is what this guy did to us. Highly likely that he's going to do it to you also.
That we have done. But the thing is, like, we want to like take it as a lesson to him that you don't have to repeat it.
So you should institute a legal proceeding, because it is at the end of the day, it is a breach of the employment agreement. You should do that as an example.
But we terminated him with the immediate effect. We, like, for that month of salary we didn't give it. But we were at the risk of breach of confidential information in this one, because he was having access to all of the servers of the company. He was working on the live project for very of the crucial clients, and he joined the because he doesn't have any other skills, so he joined any other though he joined for with the objective of earning some money out of it. But we were under the impression that he has disclosed our information to the competitor one. So I tried to, like, take him to that extent, but the case was not registered against him, because they said it's highly a civil matter. Case can't be
Yeah. It is a civil matter. You will have to institute a civil proceeding, but you should do that. Okay, so that it becomes a very clear example to the other person that the company will take action. If you don't do it, this will start to spread in other places also. And you have to make it very clear that the company takes action, and then the company institutes.
that too we got the mediation amount also. But the thing is, I was under the impression, like, if there is any of the criminal action which can be taken against it.
I'm not a criminal lawyer, so not the best person to answer that. You
Okay.
can reach out to Yash.
Okay. Thank you, sir.
Okay. Any questions that you have?
No, nothing. Thanks, ma'am.
Okay. Thanks, guys. Have a nice Sunday.